Good morning. I'm going to call together the subcommittee on House Bill 1573, and I'm going to start by calling on Krista Morris. And Chris, are you going to have anyone else from the department join you, or just? Okay, just fine. And we do have a new amendment, and I've asked her to go through that amendment, and we have a nice side by side, which will be really helpful for us. Thank you.
Yes, thank you. And I don't know if you need my name, but it's Krista Morris. I'm with DHHS as the Director of Intergovernmental Affairs. As you can tell, HB 1573 was a bit complicated. And so what we had to do, as I explained to you earlier, some of the amendments or some of the changes in this amendment were merely a copy paste issue with all the back and forth with the OCA. We had a lot of edits, a lot of track changes, and so when things copy pasted over, they didn't get in. So there are a few items in here that are that. And then there were other changes that we worked with the OCA on to make technical amendments, just kind of clarifying some language, making sure that the intent matches the language or the language matches the intent of the bill. And then on top of that, we added some language regarding juvenile justice from JRPG. They had some edits, just kind of again, wordsmithing, changing some words to meet the federal requirements. And I'll go through them line by line. I just wanted to give a high level. And then also there are some edits as charged by Representative Edwards and Representative Pearson to try to reduce the number of visits or anything, make changes that would possibly reduce the fiscal impact to the department. And so all of those changes are in this proposed amendment, and we will go through the 6 pages and just kind of highlight some of those. Okay?
Thank you.
All right, so first we have strike qualified residential treatment program. I think I explained that last time. That was just for some facilities apply to be a QRTP. QRTP, yes. Make sure I got those letters correct.
When you use letters, would you tell us what they stand for?
Sure.
Okay,
So the Qualified Residential Treatment Program, we've removed the Q from the QRTP, and that's only because that is a federal designation. If a facility wants to apply for federal Title IV foster care funding, they have to go through the QRTP process. Some states do not engage in that process, so their facilities in the state wouldn't apply to be a QRTP. Doesn't mean that that's a lower quality program. It's just a funding mechanism title, essentially. So we went through to make sure that that didn't reduce the number of facilities that we could send children to. And so we just wanted to make sure that that was lined out correctly. So next, if you go to section 1, part 2, that is under purpose and statements. So that's going to obviously have a $0 impact. It is some rewording to, again, oh, I'm sorry.
As Ms. Morris is going through this, because I've not seen this, it would be good if you could just give us
Sure.
a pause so I can read it before she starts to explain it.
Yep, I can do that.
Real working. Okay.
Okay, so again, that's where we are making sure that the language reflects the intent of the bill. Prior, it was a broader statement, so it included many more youth placed in residential facilities, including those that are voluntary youth, you know, their parents send them versus the state. And so we wanted to make sure that this is intended for children under the care of the state. And so that's why those specific RSAs are labeled in this bill. Again, $0 change. Yeah, I think that would be easier. Yeah.
So to understand the context of this question, let me tell you where I'm coming from. The epiphany I had the other day about that whatever we put into this law will open the state up to lawsuit if we don't comply with it has just got me thinking that we should try where we can to make distinctions between shall and may. Like later, we're going to talk about visits, and when we get to that, if we shall do X number. I'm wondering if we do we shall do a X, which is a lower number, with an aspirational goal, or we may do as many as 4, so that there's shalls that set it down and mays that will definitely aim at from a budget perspective. In this instance, on line 7, we use the word ensure, and ensure feels like a good word to sue us. Because if we don't, and because it says appropriate, we ensure appropriate. Appropriate is a poorly defined word and is subject to the judgment of potentially a jury or a judge, right? So I'm uncomfortable with the combination of those two words in this sentence, ensure appropriate. So that's an observation, Madam Chair. Thank you.
And so that's one of those where I noticed today on the Gen Court website, there are multiple dates for this bill. So my goal is after today, going through this with you, that these edits, these recommendations you make, I will go back with the OCA and work out to see what we can do.
And of course, that's just my opinion, and the subcommittee would have to take a position, but that's just my personal first blush.
Yeah, let's continue on with
Sure.
going through it, and we do want to get the response from the Office of the Child Advocate
Sure.
and from the court around what they see here, and then we'll work on wordsmithing it. Okay.
Right. Yeah, that's what I
Even
meant.
though we love to
yeah.
wordsmith.
Okay, so next we have section 1, Roman 4. And so this is where I'm going to call on the OCA a little bit. Some of these are your edits from the JRPG. And so I can't speak to those as well, unfortunately. Sorry, I should have called you up here to begin with. Yep.
So if I could just, nothing in this findings section is a substantive change in policy from what already passed through the House. Like Krista mentioned, a little bit of it was just wordsmithing. Here we added just one partial sentence in lines 12 and 13. A shortage or lack of foster family homes or community-based resources shall not be an acceptable reason for placement in a residential facility. And that just helps this align with the other pieces of the bill. This is mentioned other places. So we just wanted to make sure that was upfront in the purpose and findings. And that also aligns with some federal standards that you cannot put kids in a more restrictive placement because a residential facility is the most restrictive placement just because you have failed to provide less restrictive resources. So that really was just kind of aligning the language throughout the bill.
So this is a 1A and 1B question. When you say there's no policy changes in from what the House has done, do you mean, I just want to be clear, we're not talking about the current law, we're talking about what passed in 1573 previously as a kind of a new policy?
Correct.
Okay.
In this findings section.
So we are in fact changing policy in order to get the numbers to work. So So we're going to probably break some eggs along the way here from what the House has already passed, is my guess. So the B part of this is, as a person who has worked in the real world, if a shortage of a resource, if there is a shortage of a resource, it does obviously impact the decisions that get made. And so, without understanding the stronger context of this, the fact that we're saying a shortage or lack of foster family homes or community-based resources shall not be an acceptable reason. I think by definition it becomes an acceptable reason to come to an alternative because you have no resources. So my first instinct would just be to strike that subparagraph. What do you
The
want to
entire
comment?
subparagraph?
No. From where it says a shortage to the end where it says in a residential facility. I think shortages are the real world and matter.
And I think that a shortage of foster family homes or community resources is not a reason to take a child's freedoms and place them in a very restrictive facility that is intended for short-term therapeutic use.
I think Cassandra might have something she's trying to add.
So, if you don't have something, you can't use it. That seems fairly obvious.
Absolutely understandable that the shortage of resources does lead to needing to take a look at alternative placement options. What we're saying here is there's a difference between getting creative with an alternative placement option and putting a child in a setting that is considered highly restrictive. As Lissa mentioned, is the entire intention of these facilities is to be providing a therapeutic treatment. And if that child isn't in need of that therapeutic treatment, what are they gaining by being in that facility? And it can actually become much more harmful, and research tells us can lead to more problematic behavior down the line if children aren't in an appropriate setting from the beginning of placement.
So I don't have a problem with anything you just said, other than this is written in the negative. This is saying thou shalt not. And if you have a good alternative when we do not have these resources, could we write what a good alternative would be so that we have an affirmative direction to go instead of a reduction to a negative statement?
The reason, excuse me, the reason an alternative has not been provided in writing here is we do not want to lock them into one and only one option alternative. It is constantly evolving. The director of DCYF has been getting very creative around children who are coming into care where there is not an option for placement and is not immediately going to residential, and coming up with other creative options, maybe adding additional services in other areas to have a child placed there. So we're trying not to give them a one only option. We're trying to allow them the freedom, saying we can't move this child to that restrictive setting, but you have the freedom to come up with other creative options. And that's constantly evolving. Currently, month by month, we're having new alternatives that the state agency is coming up with to get creative around placement of children.
And I would also just point out, since we are in finance, residential facilities are exponentially more expensive per day than any other type of placement, as well as I heard you mention liability earlier. You know, you do open yourself up when you're putting children in placements that are not appropriate for them, that are more restrictive, that are traumatic for them. So I think, and also part of the wordsmithing was, this is language that aligns with current federal court standards about placement of children.
As well as federal funding, the Family First Prevention Services Act, which provides funding to the states. If they're utilizing residential care appropriately, then they can receive additional funding.
So to Ms. Sanchez's point about there being creativity and alternatives and some smart things we can do, there's nothing in this paragraph from lines 10 to 18 that are suggestive of what might be done in lieu of in the presence of a shortage. And if we could have some language in here to explain what sort of alternatives or thought process would be appropriate, I think that would be useful to the bill. Your words were great. They're just not in the bill. So that's what I'm saying.
I think they heard what you were saying. And let's move on. Maybe Krista can move to the next section.
Sure. So next, if you, on the amendment, line 19, section 1, Roman numeral 6, I believe this was more wordsmithing to align.
Timeout, read.
Yep.
Sorry about that. Ready? Okay.
We'll come back to that one.
Oh, we're going to come back to that one?
Yes.
Okay.
Because I'm
Okay.
going through and I copy pasted, so I'm wondering.
Sorry, if I could, I think it adds "and oversight process"
okay.
to
Oh,
the end of the
yes.
first sentence.
Yep. Thank you. I think we're a little too in the weeds on it, so we're just.
So the modification is line 21. It added and oversight process.
Yes.
Okay. And let's, I think we've got that one. Let's move on to the next section.
Yes.
Oh, you haven't?
Okay.
Representative Edwards has a question.
Thank you, Madam Chair. So on line 26, we specifically say effective 6 months later. And is it the department's position that creating the job descriptions, creating the structure, doing the hiring, the availability of potential workforce, that all of those factors that go into building this can be done in 6 months?
If we work really hard, it could happen in 6 months. I spoke to our finance. So right now, governor and council is going on. So our chief financial officer,
Yeah.
Nathan, he's over there. He will come over here afterward. But he explained, between getting through DAS for, to get a position number, to get it posted, to get all of those steps, we might have someone hired in 6 months.
Yeah, because I'm still paranoid about the litigation potential, and so I would be more comfortable with a kind of an aspirational versus a drop dead date.
If I may respond to that from the OC, excuse me, from the OCA perspective, we do understand it will take additional positions to fulfill this fully, but there are positions that currently exist that are in this role. So they need additional positions, but there are folks, about 2 or 3, that are already doing the certification. So it's not that you're building a completely new division, you're adding bodies to the division, which over time can be done. And I do believe that 6-month timeframe is achievable for that. And then it will just add to the number of them that can get out and see these facilities.
We also disagree about the number of positions necessary. Frankly, in this bill, the way it is currently written, the OCA believes that 2 to 3 positions in BCBH should cover it. There should not need to be any more positions in DCYF related to monthly visits. We haven't really gotten to talk to the court in depth, but and this is why we came, that we believe that the request is far overreaching and really truly unnecessary to even meet what was passed in the House. And so we disagree that there would need to be any additional time. The 6 months should be enough to build out 2 or 3 more positions in BCBH. And I hear, Representative Edwards, your concerns about liability. From a legal standpoint, and I have been an attorney for DCYF as well as a parent side attorney, so I've done both sides of this work. I think the release of the Bledsoe report and all the conversations that have occurred last summer, last fall, at the policy committees in both the House and Senate, there's already a liability issue because frankly, the division is really already required to do almost everything that is in this bill already, and it was not being done to the standard that was protecting children. So I hear your concerns about liability, but I think just having had these conversations, that liability is already there now.
So I can appreciate that, but I'm not going to contribute to making it easier for somebody to go against the state by putting it into law. I don't want to do that. So,
Okay.
go ahead. Yeah,
No.
thank you so much.
Okay, let's
Okay.
move on.
Yep.
Okay.
You've worked-
So the last row on page 1 starts on line 29 of the amendment. And that was, so there is well, the addition was already passed. We are removing a strikeout, and I'll let you read that, but removing the strikeout for exemption.
So in effect, does this make it easier to, for the state to find a placement option?
No, I don't believe so. This came from our chief legal officer that she did not want that struck out. And it's an exemption from inspections.
So if we have to do fewer inspections, doesn't it follow then that it's easier for us to find an alternative facility because we don't have to subject it to an inspection process? That's, I'm wondering what the practical implication of removing that as a strikeout is.
Honestly, from our point of view, we felt that the new bold language at the end of that paragraph created the same requirements. That's why that other piece was struck out. I know DCYF legal disagreed, and I would defer to them, but I believe we are chief. You guys have so many titles. Chief legal. I understand they felt, but I think the purpose of the new bold language was to capture those same sort of oversight. There was just in different statutes based on what was newly written, but I believe it should be similar. It was just spreading the duty across because some of these new sections. Because you have $0.
Yeah, it's a $0.
Yeah.
Yeah.
Same thing.
So I will explain this one real quickly to you. On line 7 of page 2, that was originally RSA 170, and we changed it to the department feels it fits better under 169, and so that's why that change is made.
Two sections that got lost.
Yes, well, good. Okay, so then next we have section 3, Roman 1, and that starts on line 10, or line, yes, 10 of page 2. This is ensuring, and again, I think this is more wordsmithing. It's making sure that any program does not receive funding from us if they are not certified, and that we do not send children there if they are not certified. And it's just some wordsmithing to make sure that that aligns. The facility must, you know, meet the requirements. So,
It also clarifies that all facilities where children are placed must also be licensed. If they're in New Hampshire, they're licensed under New Hampshire 170E. If they're out of state, they're still required to be licensed, but it's by that state's licensing body. So that clarification. It also took out out-of-state programs and just made any program, because it doesn't matter if they're in-state or out-of-state. They need to be licensed and they need to be certified. So that was just a little bit of cleanup language there.
So that's intentional, going from 13 to 14 where it says by the department. So there's no other certification alternative other than the state doing the certification.
Which is current
That's
law.
intentional.
Correct. It's
All
current
right,
law
that's,
right now.
yes, that's good, thanks.
so then next it says new sections 3 Roman numeral 2 and 3 Roman numeral 3. That's where I explained earlier there was a track changes copy paste error. I just needed to add those sections back in to the law. It creates a new certification team, which is what we were discussing earlier, as well as we shall develop a standard operating procedure and a form that we will consult with the child advocate. And this is what I spoke to, I think, some of you before. We have invited the OCA to shadow us on visits for certification and DCYF visits, so that way they can kind of see what we do, but then also provide feedback if there's anything they want us to add to our checklist, add to what we look at during those visits. So on line 25 of page 2, this is now section 4. It was previously 3 Roman numeral 2. This is again, I believe, just kind of expanding some of the language priorly mentioned, or priorly, is that a word? Mentioned prior, regarding just ensuring that the facility is licensed in their own state, and that they are licensed in an in-state facility, they are licensed by us, and that everyone is certified by us.
And that's not a change. That it's the same as what was passed by the House in February.
So a question there. Is there a break glass option on this? If we really need to do a placement and we don't have time to complete the certification, is there an emergency workaround?
I believe our team dispatches emergency staff to go and quickly certify a facility before placing a child there. So we never send a child that is to a facility that is not previously certified. It just may happen in short order. Our team dispatches, I don't know, same day, next day, and they go and certify it before we send a child there, because we cannot pay them unless they are a certified facility. They are not going to take our child without knowing that they're going to get paid for it.
Thanks, that's a complete answer.
Yep.
Thank you.
And just to add to that, since we were talking about lack of resources, there are a number of facilities currently that are certified and do not have any children placed in them. So in an emergency, they have beds that are already certified that they have the ability to outreach and
There's
utilize.
that too. Yeah. All right, so next we have starting on line 32 of page 2, now section Roman numeral 5, what was previously 3. So this is where I know the OCA will not agree with. This is the attempt to reduce the visit requirements from 4 times per year to at least 2 per year. And I say at least, so that way our staff also has that flexibility. If I call it their spidey senses start going off, they can go back and do another facility visit. And one of those visits, so one will be the regular certification visit, and then the other one will be unannounced to the facility. It will be a pop-in spot check, but broader than a check, yeah.
And presently they're required to do one.
1 per year. Yes.
So this doubles.
It doubles what is
amount of-
currently being done, but it cuts it in half by what was recommended. And this would obviously reduce the fiscal impact by that, but then also, again, gives us that flexibility to go out more frequently than just 2 if needed.
Thank you. Representative?
Thank you. So would it help bring OCA and the department together if we inserted a new sentence that says something about the department making good faith efforts to do as many as 4 a year? So that we remove the distinction between what we're legally obligated to do and what we want to do aspirationally. Could we add a sentence there about the department making good faith efforts to do more than the 2?
Currently, they're, required to do twice per year, including, and I think 1 unannounced. Is that a part of the 2?
The new language, that's what it would be.
Would
Yes.
be, so
Yep.
it's just 2?
Yep.
Okay, great.
But at a minimum.
We would endorse more than 2. We requested quarterly. I think just to bring to the forefront, and we didn't get to give sort of the context and background to this bill to begin with. A discovery that was made after the Bledsoe incident was that, in fact, the required annual visits were often, I'm going to take back often. We don't know, but we know they weren't always being done at all. So potentially we're going from 0 visits, which is dangerous, but we're trying to get data on that. We've requested data on exactly what was happening to try and get a baseline. The other issue, I think, and going back to the building out of the certification team, this is one of the places where the OCA really has an issue with the fiscal request of, they requested 8 new positions to build that certification team. Currently, they're an agency of 8, so they want to double the size of their agency to do visits that are actually already required because they weren't doing them always now. We had discussed last fall that 2 to 3 more people would be appropriate. In addition, we have data on the number of children in placements and the number of certified placements. What we don't have is the number of certified placements where there are currently children, because this only requires them to do more than once a year visits to places where children physically are at that moment. So again, it seems to be an overblown number, and we've been asking for the specific numbers of, okay, so we know there's 264 children placed under DCYF care in New Hampshire facilities.
That's 228.
228, sorry. We know there are 32 certified facilities in New Hampshire. What we don't know is how many of those facilities have those 228 kids. Presumably in New Hampshire, probably all 32. In New England, there's 28 certified facilities, only 56 kids. 56 children placed by DCYF. There's 28 certified facilities. We do not believe there are children at all 28, which means you're not visiting all 28 under this either version, whether it's 4 times a year or twice a year. And then outside of New England, so this is the big one when you start looking at Section 8, the appropriation for travel, there's actually only 3 DCYF youth placed outside of New England. We knew 2, one's in Arkansas, one's in Florida. There are also some voluntarily placed youth, so BCBH would be visiting those facilities, but there's 24 certified facilities outside New England. Certainly 5 children are not at 24 facilities. So again, we're struggling to get accurate data of where exactly people are going to have to go. You're telling us you need 8 more people and almost $1 million to go visit when we know that it's a much smaller universe. So that's where we're struggling with the appropriation piece, because we just think it does not line up with what this bill actually requires. We would love there to be quarterly visits. 2 a year is better than 0 a year. They should have already budgeted for 1 a year, though.
Yes, would it be appropriate then, just to, on line 32 and 33, put at least 2 twice a year and 1 unannounced if needed?
We would say the unannounced is always needed,
Oh, okay. Got
but
it.
we'd love that. 3 would be great. Better than 2.
Yeah,
So-
so I would be,
So I would not
Comfortable.
support that, though. I would rather have the minimum language
As
as
three.
the shall.
Shall.
And I asked a question earlier that I don't think has been addressed. Would it placate the department if we inserted some good faith language to say that the number of inspections, the department shall make best efforts or good faith efforts to do 3 or 4 a year? So I'm trying to make a distinction between what we can be sued over and what we can build policy and budgets around. That, I'm trying to help the department and the OCA by finding a middle ground approach here.
Could I just ask the department a question? So if you go out and make the one visit a year, and during that visit, the person doing the visiting from the department has some concerns, but they don't really rise to the level of that the child advocate found in the Tennessee facility. But they now can go back to that facility and do as many visits as they deem or they need to do.
I believe so.
Yeah,
But I mean, we also have written in here a corrective action plan as well for the facility to come up to speed.
okay.
Okay. And then do you go back and follow up with that corrective action plan to be sure they actually did it?
Do you want to grab a mic? Pull up a mic. Oh, please don't knock over
Why
your
doesn't
coffee.
everybody just bring their chair up?
I know.
Yes.
Everybody, come
Yeah.
upstairs.
There's seats over there.
Please.
They're kind of a team.
Good. Good morning, Rebecca Ross from the Bureau for Children's Behavioral Health. Currently, what happens is we go out once a year. The certification runs for 2 years. 1 year is the certification visit. The following year is the technical assistance quality assurance visit. The function of the visit is always the same: to look at the facility, to interview youth, to interview staff, to check records and go through things. It is more comprehensive on the 2-year certification. If there's something identified on either one, there is the certification or the visit report, a corrective action plan, and then a back and forth with the facility to ensure that they are following up. And then the next time they are on site, they're also checking in on that. It really depends on what it is. If it's something with the facility and we need eyes on to see it, or it's update this document or update this policy. Some of the corrective action items are very easily done from the office and we're not on site. Other things we would need to be on site. We certainly have the ability to go on site at any time. We do not have the resources. Currently, we have 3 people to do all of the residential contracting, visits, technical assistance, collaboration, management of individual kids, eligibility for voluntary cases, and a number of other responsibilities. So they are on the certification team, but they are certainly not exclusive to that. They've made 3 out-of-state visits in the last 3 to 4 weeks. One individual is in Atlanta today. There are times that we are going to a place to certify it, and then the placement falls through. So even though there are only 5 kids, we are still working with 10 to 15 facilities at any time to either bring them on board or do a visit to see if a youth can go. So there's a lot of back and forth and a lot of uncertainty on the visits that need to be done.
Thank you.
Question. So again, my understanding, currently you have 28 facilities in the New England area and 24 outside of the New England area. Are you doing certifications each year for all of those facilities, or only those that have children placed in it?
We are not doing the on-site visit, but we are doing the certification process to keep them on the rolls if they want to continue to be a certified provider. Some are very unique, specific providers that we may never have a youth in the next couple of years, but then 3 years from now we do.
So the question is yes. Okay, thank you.
If I could just add just that, I appreciate your question, Representative Priest. Just a couple things. So if you look at the next page, line 6 of page 3, and this has essentially been in here the entire time through all the iterations. As of the adoption of this bill, there will not be placements outside of New England without specific director approval.
Okay.
One of the main reasons for this bill is we need to keep children closer to their homes and
Right.
their families. So the 24 outside of New England hopefully won't be used at all anymore. I would also point out that the certification process currently on the books in administrative rule does require the certification to be in person, but it sounds like that is not currently happening. We had proposed language in this new section, Roman 5, because they're only visiting places where New Hampshire children are. We had requested language be added that if they are proposing to place a child there, even if it's already certified, there needs to be an in-person visit if there hasn't been an in-person visit within 90 days. Because now you're saying if it was certified January 1st of 2023 and it's now December 15th, 2023, you're potentially going to send a kid there having not, and now I'm hearing that if there wasn't a kid there and they recertified, they didn't visit at all. So now, when was the last time someone's eyes was on this facility? Because who knows what's going on there. So again, and the OCA's job is to protect children, obviously. We are always thinking about best interest, the trauma, the harm, what potentially could be happening. Because while we caught what was happening at Bledsoe, there's a lot of information out there that is not just Bledsoe that bad things are happening. Maybe not to that degree, hopefully, but some places, yes. So having eyes on facilities frequently and certainly before you put a kid there is important. But we have seen the Bureau go out and emergency certify a placement. They actually just did it in Virginia this past month. So they do have that capacity. We're hearing that there's 2 or 3 people that do it now. That's why we're proposing this new team B, 2 to 3 dedicated people that is all they're doing, because it is a lift.
Well, and if I may add, in this, we too are thinking about the potential for lawsuits and are thinking that these are actually a protection against that, because if you're there, you're seeing what's happening, you've gathered the information and know what's going on, hopefully, and more frequently, that would be caught before a child is further traumatized, which would lead to somebody
Right,
taking out a
right,
lawsuit
right,
against the state.
And
So that
frankly, if
is an
there-
intention in
If
here
there
as
is a
well.
lawsuit, due diligence was done. A reasonable person standard was met.
Question again, are you in constant contact with the other states and their certification problems? So if a facility like in Virginia suddenly becomes decertified for whatever reason, do they communicate that to you so you're on top of it and you don't put a child there if it's not certified by that state?
That's you. Yeah.
Yes, we absolutely do. When we're doing the recertification process, we're reaching out to the other states. The providers have an obligation to let us know, and we certainly have a relationship with the home state of those providers as we're going through the process. So, is it possible that something could happen one day and we don't learn that exact day? Absolutely. I think things can always happen, but yes, that is certainly part of our process and part of their obligation to let us know if their licensing status changes.
And even from a child advocate point of view, so when Bledsoe occurred and we issued our report, we have a network of other child advocacy offices. We certainly broadcast that across the country of this. We just found this at this facility to put other child advocate offices on notice. I know BCBH decertified Bledsoe after a couple of months. I don't know how that network works, but there is certainly communication.
So thank you, Madam Chair. I just have 3 points related to lines 32 through 36. First, overall, I just want to say I think everyone in this room shares the desire to protect all of our children. So so OCA, that's obviously your primary charter, but I don't want to leave it hanging in the air that the rest of us don't care as much as you do about kids. Okay, so I want to get that out there. And what you were saying about going and visiting, like I'll call it a stale certification, whatever we define as stale, going and double checking it before we place a kid there to make sure that we know what the current situation is. If that's new language in here, I'm personally okay with that. And then for the third time, I want to ask the question and try to get an answer on the third time. Ms. Morris, I'll ask you specifically. Would it be helpful if we kept the language in 32 and 33 of at least twice per year, one of which is an unannounced visit, and added a sentence to talk about an aspirational goal or a good faith effort to do more than that. Would that be beneficial to the policy and budgeting process?
I think it really depends on what you want as a result of that visit. It is, if it's merely,
It's the same thing as every other visit. That's my objective, is that it would be the same as every other visit, but instead of being required in law, we would be doing it because we think it's good policy as opposed to good law. And I see a distinction between what we put in law and what we try to do with our department's work effort.
so I think from our perspective, a unannounced visit is going to be very different and provide very different results than an announced visit, because there is a lot of scheduling in advance work to pulling files and scheduling with staff and making sure the right people are on site and available, including youth, and sending out surveys to parents and families and other staff in advance to prep for that visit. So when we're doing our announced visit, there's a ton of prep work. If we're doing an unannounced visit, we may not see any New Hampshire youth that could be on a field trip that day. We will really only be able to walk in, talk to whoever may be available and have time for us and see the facility and not get those same outcomes. So if we only want one of the structured visits per year and the other one to be unannounced, that language would be fine. If we want 2 visits per year that are structured and have that same kind of report out, then we would need a third unscheduled visit.
Okay, so I'm going to take that as a yes to my question. Yes, adding a sentence dealing with good faith efforts to do more than the minimum required would be helpful. What you just went into is a tremendous amount of detail about the nature of those additional good faith visits, and that's fine, figure that out. But I'm just trying to make sure that the OCA realizes we're hearing them, that more is more better, but I don't want to obligate the state to something that we may not be able to achieve in 2, 3, 4 years. For now, this is going to be the hot topic, and we're going to get on this and we're going to fix it. But the legislatures in 3 or 4 terms, they're going to have different priorities, different issues, and I want the law to be able to breathe.
In response to that, I was wondering if the representative would agree to, on line 32, to keep the wording at least twice per year and one unannounced visit. So there'd be 3 total, at least 3.
I'm not interested in doing that from a mandatory, going from 2 to 3, that's 50% more visits.
Right.
I just assume.
Right now, we're having 0.
So we're doing better already.
Yeah, you're right.
Because we're already at 2, right? So I would like to keep, and maybe I'm not making myself clear, because of the litigation risk, I'd rather keep our obligation under the law limited, and I'm totally okay with them doing more than what we legally obligate with this sentence that I keep talking about, a good faith, the department shall make good faith. So Representative Priest, I hear you, and I think the way to get there is by adding a good faith sentence.
Yeah. Again, my concern is with that, in good faith, is hard to budget for that. So if a case comes up and they have to come out more than an additional one, maybe twice visit because they see problems in it, then it's hard, they'll be over their budget.
So on the budgeting, I've sat through 2 budgets on DHHS, and I don't think that it's particularly difficult for the department to come up with what they think their good faith effort would be, and then be subjected to Division 3 questioning. You know, what's really required here versus what you're trying to do, and then that allows the Division 3 people of the future to allocate resources that are available for allocation. So I get your point about budgeting, but having done 2 of them, and Representative Wallner has done 1 million of them. Not 1 million. I don't think that that's the roadblock.
And if I could just point something out that I think helps support your point, Representative Edwards. Always. And I did not mean to imply other people here don't want to protect children. We're lucky that that's our sole focus. We don't have to talk about all the other stuff. So in line 36, I will note that an additional protection here is that previously the records resulting from those visits by the BCBH certification team only went to the facility. So we add here that they also come to our office. We've been asking for these records for some time. If the OCA gets those site visits, not only do you have BCBH eyes on it, you have OCA eyes on it to also potentially pick up on issues to bring to the forefront. So that's another level of protection built in, as well as the next section we're going to talk about by increasing not the frequency, but the recording of those monthly DCYF caseworker visits that already happens. Again, more reporting, more eyes, more potential for those additional non-mandatory visits to potentially happen.
So I'm good with that. I think the balance is, privacy and administrative overhead with transparency and a need to know. Clearly, the OCA has a need to know and is able to handle the privacy issues. So having access to the reports, I think that's great. I just wouldn't want to be sloppy about who else starts to get them, because I think there's sensitive information in there, right?
100%. In our statute, everything is completely confidential. So that is the place to have that extra set of eyes.
So next on page 3, line 6 of the amendment, this changes the language of no placement out. This is what Lissa spoke to earlier regarding no placement out of region shall occur after January 1. However, our proposed language is that no placement outside of New England shall occur without the approval of Jeff, our DCYF director. He should have eyes and know who is being sent out of region. Okay.
That's an excellent improvement. I just wonder if somebody was filling in as an interim, would this law allow an interim to act, or
I did
are we
ask
dead
that
in the
question,
water?
and yes, I was told yes, it does. So moving on to line 11 of page 3, this is again, the OCA will not agree with this, and I understand. Yes, you agree with the line 11 and 12. However, down to line 20, not as much. So the reason, I'll start at the top, this is again limiting the number, or the categories, I guess, of which the children fall under as to who we go and visit, and that is 169B, C, and D. We will see them, or our staff will see them at least on a monthly basis. However, and I know you're going to read this, but if you look at how it was proposed versus how it looks now, we removed essentially a lot of the checklist that was in the language, and it would move to a checklist that we would work with the OCA on, but it's not in statute. And some of that is because we did have concerns with some of the language. It required leadership meet with us, and the definition of leadership, the definition of who would be called leadership, and then also requiring a third party to meet with us. So we wanted to make sure that it allowed us some leniency on who we met with and who we felt was appropriate to meet with. And I say we, the real people doing the real work. And I'll let you read that.
Okay, on line 17, the use of the phrase safe place is mentioned. who determines what a safe place is, and does that beg to be defined?
So I'm not a subject matter expert on that. I would assume that would be the case worker and the youth would kind of, because
So,
the youth is
so when
there,
you
they'll
guys go
know.
away and rework some of these comments, would you just have a conversation about whether or not this should be more clear about who makes a determination of a safe place? I'm okay with the concept, the place should be safe, but it leads to the question of, well, who makes the determination? Does the patient say, I don't feel safe in this place, and even though it's safe, I mean, I just want some clarity there. I agree with the concept. And then the second part of that is, you and I had talked earlier, and I suggested that perhaps we could insert some language that would allow video conferencing. And there's no video conference mentioned in here, and there's a reason for not having it, I'm sure.
There is. However, I am going to swap out. Oh, go
Can I
right
just
ahead.
respond to the first piece that you pointed out here about the safe space? I conduct these visits on behalf of the OCA with my staff as well. So my staff go out and conduct visits and meet with children. That's how we uncovered blood. So in doing those, and this is the reason why this language is in here, and the expectation of a social worker would be to meet with a child and say, I'm looking to have a confidential conversation with you where you can speak to me openly about what is happening for you in this program. Said worker brings them to a conference room. When they sit down in this conference room, do you feel this is a place that you can share openly with me? Or are you concerned that others will overhear our conversation and we need to relocate to somewhere else? So that is when defining that safe space, that conversation should be happening before they go into detail about how that child is doing at the very onset of the visit.
I'm just saying, I think this begs the possibility of needing to be clear on who makes the determination, the final determination that the place is safe, so that they can go ahead and do the interview. And I open the question, are there any standards that we should mention around what
You, depending on if it's a juvenile case or a child protection case, is meeting in person with the child in a place that they have worked together before coming out to reserve, to have a private room set up in case, if the roommate is present in the room, someplace where they can meet with the child in a safe, secure, for both parties, for everyone to feel open and ready to have these open, transparent conversations. So that's already occurring in policy.
This is another question for the department. So the caseworkers are going out and monthly, and they do that now. Is that correct? They go monthly
All of the facilities.
to all the facilities and the foster homes.
To meet with the children. So
meet with the
if there's no children in that facility, no. The
No,
caseworker
yes.
and the JPPO is going out in person to the residential placement where the child is located, yes.
To meet with them. What happens if they go out and they have a concern, they meet with the child and they have a concern about the facility? How does that interact with the certification staff? Do they do they have an obligation to come back and report that they felt something was not right? I mean, what's the interaction there, since they are going out monthly?
Sure, and there's many layers to that. So each child who is placed, say, out of state is also under the confines of either ICPC or ICJ. So there's an interstate compact in which there is a home state juvenile probation system as well as a child protection system. So if it was something about that resident placement, they would alert the local CPS, local JJ, as to what is occurring in that location. If it's about the child themselves, so yeah, they would also, in addition to alerting the local child protection agency of the state where the placement facility is. They would also alerting the case itself here in New Hampshire. So the worker would alert their supervisor. If necessary, they would call for an immediate ex parte phone call to the judge for an emergency hearing on the placement of this child. So there's many safety precautions and safety reactive means to make sure that everyone knows that there's something going on in this facility, even if it's not related to the child itself.
I do want to clarify the ICPC process. The ICPC process does not assign a social worker from the state that the child's in to do monitoring visits if the child's in residential. That only stands if the child is placed in a foster home. So ICJ is separate for juvenile justice, but for ICPC placements, the New Hampshire would be the sending state. The receiving state would only assign if that child is in a home setting. If they're in a residential setting, the CPSW from the state of New Hampshire is still the assigned caseworker. They are responsible for going out for those in-person visits to the child. And it is, as mentioned, as Susan mentioned, it is in current policy, current DCYF policy, that they are to immediately alert their supervisor. But it does not, there is no clear chain of command beyond alerting their supervisor in that policy. So as we speak here about developing a standard operating procedure, those are some of the pieces that we would look to make a bit more clear. How does that messaging then get over to the BCBH team and not just live with that worker and that supervisor?
Well, and Representative
Thank you.
Wallner, I think your question gets actually to the heart of the purpose of this bill and sort of what came out of Bledsoe. The discovery was made that those worker visits, so again, we talked about sort of the buckets. There's the BCBH certification team visits, that's about certifying the facility. There are these DCYF or JPPO worker visits, which are, they're assigned to that kid. And then the court oversight piece we haven't gotten to yet. But so what is happening, or at least was happening in some places, including Bledsoe, the worker assigned to the child went 15-minute visit, laid eyes on that child in a little conference room, didn't see any part of the facility, didn't talk to anybody else at the facility. And that was the issue, that how would they have seen all the red flags that the OCA saw? Because they literally walked into a conference room, 15 minutes, eyes on that kid, okay, everything's great, got back on an airplane. So that's why this piece of the bill is so important, and why the original language is so crucial, and why this amendment essentially undermines the entire purpose of the bill to avoid visits happening like that anymore. If you're just going to see a kid, potentially one you've never even met before, say, you know, how are you doing? How's your permanency plan? How's your education? How's your treatment? Good, good. And then don't actually talk to the treatment provider. Don't talk to the direct service staff that's actually with this kid all day. Don't talk to any other person or adult in that facility. That's where these things happen. That's where your liability is. In a foster home, they go in, they talk to the foster parents, they talk to the other kids in the home. They're going to talk to the teacher, the therapist, you know, so this is really intended to mirror the level of contact and information you're gathering about a particular child who is on your caseload into that residential setting, because the direct care staff is like the foster parent. The leadership is setting the rules. The therapist is the therapist. So that's the very heart of this bill. And I'm glad that you asked that question, because that is the problem with the way things work now, and why we felt it's so important that it needs to be a lot clearer in law, because the policy already says that stuff, but that's not what was happening.
Well, and to make sure it's clear, for those who maybe haven't had an opportunity to read the full Bledsoe report, there were, as Lissa mentioned, workers that had gone out once a month for the entirety of the placement of the 2 children that we met with, and not one concern was documented in their case record. Not one about this facility. And if you read the lengthy concerns that we were able to observe in one visit, we're noticing that the visits that are happening by the workers right now are not capturing the same level of information.
Are the caseworkers required to, yes, meet with the child in a safe place? Are they also required to see where the child's sleeping arrangements at every visit?
Yes, they tour the living quarters of that child, as well as all common areas that that child goes to on a day-to-day basis, whether it be the library, the gym, the cafeteria. And again, I guess we're now moving on to, I thought we were still talking about just a safe place, but it appears that we're talking also about the visit itself. Yes. The reason why we had concerns about what was labeled in the visit, in the original 1573 was a lot of shells that were beyond the control of the caseworker and put the caseworker in a position of being a quality assurance representative, which they're not. Of course, when they're in the facility, their heads need to be on a swivel. They need to be taking notice of everything that is going on in that facility. But there were a lot of shells that were beyond their control, such as tour of the entire facility each time they go. Every 30 days, they need to tour the entire facility, way beyond just the facility of the portion that the child is. So if it's a co-ed, they'd be looking at, acres and acres of property that is beyond what is their child's needs, what their child is exposed to on a daily basis. They would be shall discuss with leadership the program culture and therapeutic program. They shall have discussions with the program direct care staff. They shall have discussions with the clinical director and or therapeutic provider about the program culture, therapeutic programming. So again, things that go beyond just what's going on with the child, things about the entire facility, which again is putting us, we feel, in a liability issue in terms of the shells that are involved. And that's why in our amendment, it was much more talking about the child itself, themselves, right? Discussing their treatment, their education, their transition planning. And what is also already occurring, which occurs either live through a Teams or through written correspondence, is updates, is being part of their therapeutic treatment meetings, talking with the clinical placement provider, speaking with the therapeutic providers and educational providers, preferably in real time, but at least by written correspondence, as opposed to the original bill, which said that all of that was happening in person during that 30-day tour. Because sometimes those program meetings are not at the same time as that 30-day meeting with the child. So they're focusing on the child at that 30-day visit, and then in addition to that, they're being involved in the treatment team meetings, whether it be by Teams or through written correspondence through email. So it's much more than just that 30-day visit. However, the way the bill was written, everything was to occur during that 30-day visit. It's why the fiscal bill was so high in regards to, first it was the caseworker each 30 days, so that would require them to be at these locations for multiple days in order to be meeting with, leadership, the program direct care staff, the clinical director, the therapeutic provider. So again, there were a lot of shells in that original bill.
And so,
If you look at the amendment that you all had last Monday, that was agreed upon language between the OCA and the department last week that had vastly different language, including agreed upon language limiting the facility visit to just be parts of the facility that the child had access to, because we understood how they could misread that language, and cut down some of it. And this is completely new and different, stripped down language that frankly doesn't even rise to the level of what is supposed to be happening now. And the problem is that stuff was not happening. The 7 visits to Bledsoe were in a tiny little conference room. They did not see where the children slept, or they would have seen that they were on mattresses on the floor. So we appreciate that there is a balance, but I find it very difficult to understand how talking to direct care staff who's providing the direct care to the child about how that kid is doing and what the milieu culture, the milieu is sort of the common space where children are all day, doesn't relate directly to that child's care. That's not a facility visit. You're asking about the programming, the discipline, the education that particular child is being provided by those people you are talking directly to. So
Is it your position that this language precludes all that smart, common sense inspection?
It is our understanding that it's not happening now, and if it's not clarified in language, it's going to continue to not occur.
So I would argue that.
Right? I mean, that's an assumption. But is there anything in this language that precludes the common sense inspection that you're saying is required?
I believe we're missing a lot of really pertinent information. I mean, as simple as the discussion around the treatment team meetings that workers are to be engaging in. Our office received a notice within the past 2 weeks that workers are not attending those meetings on a regular basis. It is to be assumed that they should be. It is by statute, and I'm not sorry, by statute, by policy that they should be attending them. It is not happening. So again, without that shall and by leaving something with a may or by pulling out the substance of it, it may be an assumption that it's not going to happen, but I also cannot assume it is going to happen. I do not have enough evidence of current behavior by the CPSWs that this is what is actually going to occur.
And I wanted to point out too that the one part of this that was agreed to was that change to the first section, specifying that these are only for court-ordered placements under 169B, C, and D, which are already monthly visits that are currently happening already. By taking out episode of treatment, that should eliminate any new positions necessary or any new travel funds necessary, because as has been repeatedly stated, these monthly visits by caseworkers and JPPOs under B, C, and D already happen, are already happening, are already budgeted for, the travel's already happening. The additional conversations that were in the original bill, and frankly, even the amendment you got last week, which was agreed upon language that the OCA approved, really should not increase. We're not asking them to do a facility visit at all. And I went to Florida a couple months ago. When we walked in, it was a member of leadership who walked us to see the kid. You go see the kid. It's a direct service staff who's standing right there. It's not like we're asking them to sit down for hours with PowerPoints. When you go into a facility to see a child, you are naturally and normally going to interact. There's always a member of leadership present, unless you're visiting in the middle of the night, which I presume they're not doing. There's always a member of therapeutic team on site. It's a residential facility. The children are secluded there. Every single person they interact with, it's a 24/7 staffed facility. It's not, I think the way it's being explained is, again, overreaching of really what OCA was asking for in the original bill that passed, even in last week's amendment. This strips out everything and just leaves it to policy, which we know is currently not being followed and is not protecting children.
Would you point out in the amendment from last week exactly where the agreed upon language is?
Yeah, I got to
Yes.
be honest, I didn't read last week's amendment knowing that we were going to be doing that.
Representative Pearson's amendment, so I'm looking at 09H080, is that, are we on the same amendment?
Yeah, that should
Okay.
be, yeah.
So this was language that we had all hammered out together previously. It is page 2, page 2.
Yeah.
Section 3,
What line number?
line 20. So starting at line 20 to line 33
Okay.
is the language we all agreed on together after multiple meetings, except for taking out just in line 21 or placement for an episode of treatment. So that would have pulled in BCBH voluntarily placed kids and would have required additional people, for sure. We took that out. No additional people should be needed. These visits are happening, and this language was in fact compromise language. It is less than what was in the original bill as passed by the House. We sat and had a productive conversation about where, the entire facility versus what's accessible, but still includes all of these important pieces of information that the worker should gather. This directly relates to that child in that placement. And this language today, totally different. We've never seen it till an hour ago, and does not address the issues that were discovered and are occurring.
So part of this, so the reason there is a difference, she is correct. We agreed upon that language, but it was but now with the charge of trying to reduce some of the fiscal burden. We removed that section because we can add it to the form in consultation with the OCA that's in the next section, but then also it allows for some flexibility to determine who we should meet with versus shall meet with these people. We can not manipulate, we can determine and deem who is appropriate to meet with. Also, some of these discussions could be had over the phone and not in person necessarily. So that's why we just removed it so that we could add it to the form to meet in consultation with the OCA. And then also, as I stated earlier, we have asked that they, shadow some of our visits so that they can say, hey, maybe you should look at this and look at that as well. So we aren't trying to shirk the responsibilities. We're trying to make sure our staff aren't there just, okay, I met with this person. Okay, they're really having meaningful conversations and they're able to drive that based on what they are experiencing at the facility and not beholden to a checklist in a statute.
And in all candor, yes, if this amendment is agreed upon, the fiscal note for the travel will basically go down to zero. Because we are doing this on a monthly basis. If it goes from shall to may, when it comes to talking with the leadership and the providers in a way that can be done at a later time, but within that month span during a Zoom or a Teams or by written correspondence, then of course the social worker and the JPPO can be doing these visits as they're doing now, and that would reduce the fiscal note considerably.
So you just mentioned the word may. I'm not seeing any mays. I'm seeing on line 18, at the end of the last word of that, line 18 on page 3 is a shall.
I apologize.
And I just want to understand your point,
That was our original.
because that's still a shall.
Correct. Our original internal discussions had may, but we left it as shall in the amendment.
Okay, clarification, where you say that these preferably in real time, that we've mentioned Microsoft Teams, a video conferencing technique, would that be an acceptable way to conduct a real-time discussion when you're talking to the managers and leaders and case managers?
And I think that's why we defined it as
Is that a yes?
preferably in real time. Yes. It's very broad. We kept it broad for a reason, right? Because it'd be Zoom, Teams, any form of real-time
Yeah, okay.
communication.
No,
Yes.
I understand your testimony. Thank you.
I think there's a definite middle ground that the division jumped right over, going from the agreed upon amendment to this language. Exactly what you just said, Representative Edwards. You could give them the option of doing a Teams, but still lay out who they need to talk to. The idea that we don't need to put it in statute because we're going to follow what the form says seems very disingenuous, because they don't, the form would essentially create the same checklist. Intent aside, if you're saying we're going to put all that stuff into a checklist form that says here, then why wouldn't it be appropriate to put into law the types of people you need to talk to, which is still general?
I can see your concerns about the effectiveness and whether or not we execute in the way that you want to, but I just don't want to imply that anyone's being disingenuous. That's not the way to have these conversations.
I think the key point that has not yet been clear to me, and that I think is important to discuss in this venue, is how adding a very clear outline of what CPSWs or JPPOs are required to do, how that requires additional positions. I'm not seeing that connection. I'm not hearing that connection. I am hearing that we're potentially making it easier by giving them a guide to go by, as opposed to guessing and assuming what they're going to do on those visits. So that's the point I've not heard argued.
But we're not there yet. I mean, to me, I'm a simple guy. I'm just trying to go line by line to understand each of the major points of this, because in the totality of this creates a workload benchmark that later we come back and we talk at later what the manpower would be needed to satisfy the changes in the workload. These words are workload related, not, we haven't gotten to the point where we're allocating manpower to them yet.
Well, I'm just, this is my question because this point was, this piece, this specific section was represented as being reduced down to be able to decrease the number of CPSWs, but I'm not understanding that link, that
all right.
piece hasn't been clarified for me yet.
Well, I mean, I think we could say that if you increase someone's time at a facility and multiply that so many times, that increases one's workload. So therefore, we would need additional staff to handle workload. But
Excuse me, but I'm hearing both sides saying that you don't need additional staff for this particular function.
so when we wrote the fiscal note for 1573, it was as it passed the House floor. We had to stick to that. So that is where that episode of treatment, that's where that fiscal note ballooned. As you know, we did agree upon the language to reduce that, remove the episode of treatment language, so that will reduce the fiscal note. But we still, because it would be it's still, if you're expanding the visit, you're expanding their time there, you're expanding that workload, that will cause an increase in workload. So therefore, it would require an increase in a nominal increase of staff.
And that's, we agree that the visit would be slightly longer. It should be a de minimis increase in staff, maybe by some hours. It should absolutely eliminate that travel request because these people are already going there. And in addition, as we talked earlier with where these facilities are located, 228 inside New Hampshire. So that's mileage. 56 in New England. Again, just mileage. You're talking 3 children where there's any travel. And again, they're still already getting on the airplane and going there. So that's where we are confused about why would this require any additional travel, but frankly, it should be a de minimis increase because what they're saying is these things already happen. Maybe it's happening over Teams or virtually. Maybe that is the solution, is build it in that way, but 22 new people to do visits that already happened, that's where our confusion lies. We thought taking out that episode of treatment should completely eliminate the request for more bodies, and there shouldn't have been any more travel to be related, so.
So I guess I'm now getting confused as to the fiscal note for what are we talking about? Because right now, our fiscal note is based on how House Bill 1573 passed. And the way it passed, it would require an in-person caseworker to be doing the 30-day visits, which they already do, and to be in person at these treatment team meetings, to be able to have these conversations required under 1573. There are currently 287 youth placed in residential care. 93 of those are outside of New Hampshire. And it was the caseworker assigned to the case was also how it was written in House Bill 1573. So again, that's 93 outside of New Hampshire visits, which would be a lot longer and also possibly under multiple days because of that treatment team meeting needing to be in person. So if we're talking about the fiscal impact of this amendment, yes, there would be no fiscal impact for travel because the caseworkers are already doing these 30-day visits. However, they're doing these 30-day visits with the ability to have the treatment team meetings by live Teams, Zoom, or written correspondence. So yes, the fiscal note would be dramatically decreased for this amendment. We haven't done a new fiscal note just because how it was left the first day of the Finance Committee.
So I did ask Mr. Ripple to, he's going to work on, it's not going to be a new fiscal note, but it's
Right.
going to be a
So we can do a
analysis.
fiscal analysis of the proposed amendment. I would suggest, though, that we would like to have a final, complete, official OLS amendment before we write anything on that.
Right. Yeah, okay. I guess the other thing I would like to, at some point, try to get a handle on, particularly around the travel line, is I cannot remember how much is in the existing budget for travel. And I guess that would be sort of a Mr. White question at some point, not right now, but as we go on, I would like to know how much is in the existing state budget for travel.
Within. Madam Chairman, I just need a clarification again, because I heard the number of 96 people, children being outside of New Hampshire. And before I heard 56 in the New England area and 3 outside. So where's this 96 children that you talk about?
So as of March 8th, 2024, there are currently 264 youth in New Hampshire, 88 youth in the New England area, and
I think the confusion
5
is
nationally, which is 3 DCYF and 2 BCBH.
Susan's including the BCBH voluntary youth place
Episode of treatment.
under this original amendment that was passed by the House. Correct. So by striking episode of treatment, which we've all agreed to, you would lose all those BCBH place youth when you're talking about monthly worker visits.
Yes, so the numbers that we provided to you are strictly
For the month.
children placed by the Department of Children, Youth, and Families.
Yes. Yeah, sorry,
Yeah,
I
yeah.
apologize. There are currently 176 who are placed pursuant to abuse and neglect, a 169C case, and 93 youth placed pursuant to a juvenile case, 47 chins and 46 delinquency.
Yes.
Okay, so on lines 18 through 20, it places an obligation on New Hampshire state employees that we shall contact the following enumerated positions. But those enumerated positions may not be under the authority of the state of New Hampshire, and expecting us to do something that our other party may not have time for. They're on vacation, they're sick, they're in transition. I'm a little uncomfortable with the use of shall in that instance, because we don't have the authority to compel their participation. And so I think I'm comfortable with directing our state employees to attempt to meet with all of them, but I don't know that saying they shall is appropriate.
They are required to present this information for court reports. They're required under federal law to check in with these providers that are providing treatment to children. These are also paid providers to provide this treatment for children, so they are required to talk with those who are the custodian of that child. So this is already a requirement that we should be aligning with, ensuring that our statute aligns with the federal statutes and not limiting
When it's
or reducing
required-
that in
And
any
that's
way.
why we include a written correspondence, because
It's written.
federally it's written correspondence that they're required to do under the federal law.
In
So
order
that's why
for
we,
the
sorry.
court to make a reasonable efforts finding to get Title IV funding, they have to.
So I guess I would have rewritten the federal law then, because you can't order somebody to do something when they don't work for you and you can't fire them. I mean, this is just not practical but I can understand it's federal law, so I won't assume that it makes sense.
And if
They-
you want
they
to
do
change
work
it, you
for
need to
them
run for a
under-
different office.
And they are contracted providers. When we place a child, as you said at the hearing last week, like, we are paying them. There is an agreement, whether it's an actual contract or the certification. So they are required to answer. If they don't, you're right, we don't have subpoena power.
So this is where I am actually going to pass it off to the OCA because I have not had much to do with the court piece. However,
Is there any issue with 21 through 23? I think you're dismounting just a moment too early.
That's just the form.
oh, that's the form that we agreed on, basically stating that we will create a form and a standard operating procedure in consultation with the OCA as to the monthly child visits as it pertains to the previous paragraph.
And it was just clarifying some language, taking out
Yeah.
language that wasn't necessary to be in there. So
Yeah.
that was agreed upon by all.
Yep. Now on to page 4 of the spreadsheet.
Yeah.
This is the court oversight piece.
That's when the court, and Erin had to step
Oh,
over
okay.
to Division One because she has a bill that she needs to speak to them about.
Okay.
So
We
can we
can-
move to
Different stuff.
a different section that doesn't involve the court?
We can go on to the last section, which is the report. Page 6 of your spreadsheet, which is, I believe, also the bottom of page 5 of your amendment, starting on line 31. And that was the department would like to show good faith effort, everything of that nature, to issue an annual report as to how we're doing with this bill. And so we would like to provide that to the policy committees that passed this legislation, as well as the Children's Oversight Committee. The change is we had just thrown it in there, so we put in consultation with the OCA because we thought it could be a joint effort, but because of our natural siloed roles, they didn't feel it was appropriate for them to be added. That's fine. We just removed their names from it. That's all.
Yes.
So, two questions here. Is there any concern about this report being stripped of any personal information that we're writing this report consistent with privacy expectations?
Absolutely. Our department does not
Super.
issue.
Second question. In the list of those that you would distribute to, was consideration made to providing a copy to the Joint Oversight Committee of Health and Human Services? We have a chairman here from that committee who might have an opinion, but this feels to me, from watching you, that you would like a copy of this report as
He's
well.
actually also chair of the Children and Family Law, which is the one that passed this bill, and that's why that was.
So they didn't think of us, is what you're saying.
Correct.
Right.
We can add you if you would
I-
like.
It's not just me, but I think in the future,
Well,
we
right,
want
but-
what's the official name? The Joint Health and Human Services.
Oversight.
Yeah,
I
yeah.
would also note the OCA should probably be added to that list too. We got taken
Did we
out of,
not?
nope, we're not.
No, I think.
Because I think
we
when we
all
thought we were
worked it.
working with you, obviously you would have a copy. Yes.
Okay.
Thank you.
The OCA and
The
Health and Human
Joint
Services
DHHS
Oversight Committee. Okay.
I'll find the title. So that's it.
That's it. Well, that's,
Well, we have the court oversight piece as well.
Yes.
but yes.
and I think we're just going to have to wait until Erin comes back. For
Sure.
her to go through it with us. Okay, so maybe we'll go
Wonderful.
on a little break.
Little break.
So do you want to talk to them about the timeline that we're on, what we're trying to do?
Yeah. That,
Yeah. Monday, I think it's Monday, we are meeting in full division.
Yep.
And at that point,
Are we, Division 3 has a work session on Monday
Yeah.
afternoon?
Yes.
Okay,
right, in our full division.
right.
And then again, we'll be voting on Friday.
okay.
We'll actually be, and on Monday, we're gonna come up with we'll
Yeah.
bring forth an amendment to,
Yeah, Monday,
50
Monday is the last day to have moving parts, you know? If we're still yet another amendment, there's a little bit of time, but it can't be so significant because we have to vote on Friday of next week.
Right.
So I think we're working really hard at figuring out how to say yes to each other here. So,
okay? It would probably be helpful if, if there are places that the department and the Child Advocate's Office could work together to see, if we can come to some agreement about some of these pieces that there seems to be a lot of controversy about, and try to work through some of those, and so that we can be ready for Monday, have
Right.
something for Monday.
right, Monday,
And then once-
ideally, we're done.
Once we have that, Kevin can start to do his fiscal analysis for us, and that will be really helpful to get that done, because we're going to need that in order to talk to the rest of the division about the bill and the cost. Great. Do you have more questions?
I don't think so.
Okay,
We're good. Thank you.
good.
Thank you.
We're in recess for a few minutes, and I'll go see if I can, I think maybe Kevin stepped over to see how much longer Aaron's going to be.
I could use a moment.
Yeah, I imagine you will be right back. So I'm going to call us back to order.
On the sustainability issue,
Yes.
whether it's.
And I think that's very important.
Right.
Seems like a sidebar conversation.
It
so-
is.
Okay,
It is totally sidebar.
good.
Okay, back to the judicial.
Yeah, when we get Aaron. So Aaron Creedon from the judicial here and can help us go through those sections. And this is the first time we've heard from the court, so, please,
Yes, please.
yes, that would be great. And then, I'm really looking for their response, you know,
For sure.
what's,
Um,
sorry.
So this section of the bill is substantively the same as what passed the House last month. The changes are in some tweaks of wording. We worked closely with the Juvenile Reform Policy Group, which is made up of a number of community advocacy groups, including folks that represent children in these cases. So New Hampshire Legal Assistance, Children's Law Center, DRC. So most of the changes between Representative Pearson's, that's not the right one, amendment that passed the House 0427 to this amendment, proposed amendment, is tweaks in language as far as aligning with the federal standards. So it would be language like, instead of saying appropriate placement, the federal guidelines require it to be the most effective and appropriate level of care for the child in the least restrictive environment. So it essentially means the same thing. They just wanted the words to be the same as what is required under federal statute. So that's what the changes are. Substantively, the reason for this portion of the bill, and I think I mentioned earlier, this section also passed attached to SB 417 yesterday in Senate Judiciary, because that bill also talks about residential placement. If the goal is to reduce the number of children in residential placement and to make sure that that residential placement is tailored to the needs of that specific child for short-term needs-based care, the judicial oversight was a big part of it, of, well, who orders that placement? It's the court. Who's going to order that kid out of placement? It's the court. We had also gotten some feedback from judges in the judiciary after Bledsoe that there was a feeling that they didn't really know that much about residential placements, particularly the ones further away, the ones that they weren't frequently placing at. They were only getting the information presented by the division, and it wasn't as thorough as they would like, as far as, you know, the level of assessment really having the terminology required by federal law as far as when you can place a child in, as we talked about, that most restrictive setting. So this just sort of sets up the layers of evaluation and the information that the court needs to make that decision. And again, from a liability point of view, if a court's making an order, we want to make sure that on the record is substantial information of why that order placing a child in a very restrictive placement is necessary. So this is sort of split into before the kid gets placed, now why while the kid's placed, and how we're getting the kid out of placement. One other tweak we did make after talking with Aaron was just sort of allowing an emergency escape clause, like you asked about earlier. What if this kid needs to go into emergency placement? Allows the court a little bit of time to be able to get the information after the fact if the department's making an emergency placement, more in the juvenile justice arena, because those placements literally can happen in the middle of the night and they call a court in the middle of the night, or judge. So the first section is prior to placing, unless it's an emergency, the types of assessments and the findings being that the child's needs cannot be met in a home-like setting, and then what they are required to meet. This amendment also requires a little bit of language around what the school districts need to be doing, because there is both state and federal law about the school districts still need to be requiring education for these children in residential placements, particularly in that special ed arena. So that's the differences between the two, was just sort of tweaking some of that language. Overarching, though, is this desire to get children, make sure they're in the right placement first, and then get them out of that placement as quickly as possible when it's appropriate. So I think the fiscal note relates to the increased hearings. So currently, children in placement get hearings every 90 days under 169 CBD. Those are regular review hearings. So under this provision, a child that goes into residential placement would get hearings every 60 days unless the very specific circumstance where the child or the child's representative doesn't support the residential treatment program level of care, or the guardian ad litem, which is currently in law, objects to that placement, then it would be 30 days. And again, the hope is these more frequent reviews lead to the child coming out of residential placement quicker. As soon as they're out of residential placement, it goes back to the 90-day review. This only applies to this 287 kids we have been talking about that are placed by DCYF under 169B, C, or D into a residential placement. So out of the 1,300 kids in care, DCYF care, only 287 of them is who this would apply to. And only for that limited period that they're in placement.
Hello, my name is Erin Cregan. I'm the general counsel for the judicial branch.
Say your last name again.
Cregan, Creegan. I've sometimes heard it said it's Irish for horse from overspeaking. I looked in a names book and it said it comes from the word in Irish for horse from overspeaking. So I don't know what that says.
So are you an attorney?
I am an attorney. So I don't know. It must have been bad for that to end up being our name. But there are other interpretations. There are other translations. So I thank you for the opportunity to speak on this. I know I don't appear before you as much in Division 3, and so if you'll forgive me, I often point out, and I haven't spoken with folks as much, that the courts generally don't take policy positions on bills. We do point out court administration or enforcement issues, but there are a lot of different ways to solve this policy issue or to address it, and we usually would not say do this or do that, because that's the role of the legislature. You're hearing from a lot of the interested parties, and we're happy to provide technical feedback, but we don't defend or oppose different bills. We just bring whatever you find useful to your evaluation, and then you tell us how you would like us to handle these cases. So the fiscal note that we submitted was based on the about 300 number of residential placements, which the OSA is referring to. I think it was 297 in their last report, so rounded to 300, that if that moves from 90 days to 30 days, instead of having 1,200 hearings a year, you would have 3,600 hearings a year. I understand that there's maybe just a difference of opinion on how likely it is that there would be a hearing every 60 days versus every 30 days. As I read the amendment that passed the House, there is not a standard that needs to be met in order for there to be a 30-day hearing. So it is just if any party requests to have a 30-day hearing. I think, I don't have a specific number of how frequent this is, but I did talk to a few different judges that do these cases frequently to get at least their anecdotal sample. And what I heard was that it is almost always the case that, certainly in an abuse and neglect case, that the parents are seeking the return of their child. They have an attorney who's paid for by the Judicial Council, so they're not resource limited in their ability to file a motion or request this hearing. So I do expect that, and it's also my understanding that children generally want to return to the community that they're coming from. So they are seeking a foster placement as opposed to residential placement. So it is my expectation that it would be much more likely than not that there would be 30-day review, because there would be someone objecting to the continued residential placement, if not the child or their representative, then one of the parents potentially seeking the return of the child. So I think that the OCA's view is that if you move from 90 to 60, it's only a 50% increase in hearings, 6 a year versus 4 a year. And it is really my expectation that it would be closer to 12. I'm not trying to frustrate the underlying policy objective of the bill, which is to get more judicial involvement, more hearings, more timely, more process, by suggesting anything that would frustrate that policy objective. But if it is a part of the policy objective to have fewer 30-day hearings, there are things that you could do. You could say only for good cause, have every 30 days, or otherwise it's 60 days. That may not be enough to meet what's being sought in this bill, but it is my expectation when I made this estimate that it would be 2,400 additional hearings a year, which at a rate of about an hour and a half, assuming a judge takes about an hour and a half to prepare, do the hearing, and issue all necessary rulings, would be 2 full-time judicial officers. The staff estimate is just based on a weighted caseload study that we did in July of 2022 that showed that abuse and neglect in residential placement cases take a very large amount of clerk time. They're confidential, they're paper intensive, there are a lot of hearings, so they just happen to take up a lot of clerk time. So that's based on our historical understanding of how much clerical work goes into these types of hearings. It is a big round estimate, so it's just taking the number of hearings times a guess at about an hour and a half of judicial time and a past standard on how often we use, how much clerical time we use in these case types. So that's how we arrived at this estimate. And there are certainly ways that you could reduce the cost, but I don't want to suggest something that would also frustrate the policy objective.
Okay, so let's back up to the beginning of what you were saying, Ms. Criggan. This division understands the Department of Health and Human Services really, really well. What we do not understand, because we're not exposed to it, is the way that the judiciary works. And your explanation of how you did your workload count is all great. I would just encourage you in this instance, in this bill, to give yourself permission to think a little bit differently. I know what I don't know, and I don't know how the judicial aspect of this works. And I like the idea that you support that we want to maintain a policy objective. But what I need and what I hope you're comfortable with is to help us take a look at the processes that this law would define and impose, and see if there's maybe another way to do it in which we can still maintain quality and appropriateness of the timing and result of the decisions, but maybe do it in a less restrictive, more flexible manner. And I think I heard you say something about, that maybe there may be an alternative to where we can do some of this on an ex parte or an emergency basis, as opposed to as prescriptive as it is. And I don't want to put words in your mouth. I just am not fully understanding what your workload is, and if there's a smart way to change the workload requirements as this law would do, while still protecting the children.
Thank you for the question. I think that Ms. Massio was mentioning that there was an emergency exception put in at our request just because we weren't certain what the legislature's intention in an emergency situation where we could not do this full process, where we have to place a child maybe that day, that night. And we might not have assessments from when they were 8, all assessments. We might not have the documentation to the level that you would desire to have in a fuller and more planned, premeditated hearing. And I see that was added, and that's appreciated because we just want to have the guidance of the legislature on what we do if not this full process.
Which section is the emergency page?
Page 3, line 27, added except in emergency situations. I would note, though, that it looks like the other language I proposed to DHHS did not make it. Couldn't find it.
For the rest of the emergency. Yeah.
So there's more to the emergency. I just noticed while I was looking, there's another paragraph for the emergency situation, which would tell them what to do then. And it sort of mirrors language in HB 535, which the House passed related to giving counsel to children in residential. So what it says, and I can give you this language, In the case of an emergency necessitating immediate placement, to make that allowed, the department shall notify the court within 2 business days of such placement in order for the court to make all those findings in the paragraph 1.
So I would ask the smart people to see if there's a way, because I'm just looking at it as a workload issue in theory, is if we reduced the prescriptive aspects of what we must do through the court system with a more responsive, flexible emergency component, then that would possibly be a way in which we could take some of the overhead costs out while still preserving what we're trying to do, which is to give good judicial review of each kid's case when the kid's case needs to be reviewed.
So we definitely have a suggestion, and unfortunately, we had not gotten to talk to Aaron before. So I hear how they're interpreting that 30-day piece, which sounds like the big bulk of the issue. I think 2 things we could easily do. We had intended for the objection to be really that the residential placement doesn't meet the child's needs versus just anybody gets to say, I don't want them in residential care. So we can certainly take the any party out and make it clear that it's when the child or the child's representative, which would potentially be an attorney under those other bills, says, court, it's not meeting the level of care that all these assessments are saying. A more technical issue, not just, I don't want to go to residential care, because that was not our intent, but I do understand why it's being read that way. I think another good solution to again, cut that cost without losing protection is if the objection is made that you're not meeting the level of care, have the hearing at 30 days and then after that every 60, not have it keep being 30, which would again reduce the cost substantially. I would say, so currently anybody can file an ex parte motion whenever they want. If somebody sees an issue, particularly if children in residential care are granted attorneys as passed the House in January, you can always file an ex parte saying something bad is happening. And we hope that people do. I think the fear of that, the other side of the liability issue, though, is again, we're having all these conversations about the harm caused by residential care. If you wait for something bad to happen and then file something, now something bad has happened. So I think we're trying to balance the having increased oversight so nothing bad does happen with not overbearing on the system.
So to that point, we're increasing the amount of surveillance on the part of the case managers. I would assume that the greatest future source of ex parte motions would be from the case managers, because they would be the ones explicitly looking to see if something is afoul of the certification and just decency.
Having been a DCYF attorney, I would not assume that. I think if a worker saw something going on, they would probably go to their supervisor, maybe to BCBH. Typically, the division, and maybe Susan has a different take on this, wouldn't. CP workers can move kids around without court order, so I don't think they would be filing a motion. They would start investigating new placements and move the kid. I would envision there'd be the child's attorney potentially that might file emergency motions based on what they're perceiving as their client's needs.
Okay, but so this is a new area to me, so I'm sorry if this is really basic, but does every kid have an attorney? I would imagine this is a really underserved population, and they don't have attorneys running around. Why wouldn't we want the case managers, as part of their duties, to potentially file a judicial review request?
Right. And I think overall, I feel like we keep leaving out juvenile justice with these cases. So with juvenile justice, yes, every CHINS case, every delinquency case, they have an attorney. And that meets 93 of those kids are juvenile kids. As Lissa pointed out, there are two bills that are moving forward in the legislature this term that would allow for a child to not only have a CASA GAL appointed at the time of a CPS case, a child protection case, a 169C case, they will also may have an attorney appointed to them, and if they're in placement or placement is contemplated, they shall have an attorney appointed to them.
Okay, so that's good education, thank you. Do we currently, or do we anticipate having the case managers also be aware of their kid's attorney? So that the case manager is encouraged to contact the attorney if they see something wrong? Is that part of the process, or it's a dumb thing to do? What is it?
No, and I think that's what written into both bills, how if placement is contemplated, an attorney shall be represented, appointed, and they shall represent them at treatment meetings as well, correct? Similar to JJ?
They are able to if they choose to do so. I would say, coming from a state where all children and child welfare worked in the state of Massachusetts, all children and child welfare were assigned attorneys. And yes, it was the responsibility of the caseworkers to communicate with those children's attorneys, make sure that they were aware of any concerns, update them if there was something that they learned that the attorney did not gather the information first. So if we're looking at best practice, if 535 continues to move forward and we are looking at best practice would be that there is some form of open communication between both parties.
So in the prior sections that we reviewed today, there was no mention of the responsibility of the case manager to also conduct periodic conversations with the attorney, neither periodic nor exigent. So I'm just wondering, did we miss something that we should put in here?
No, the reason why that isn't in there currently, in part, is because we're talking about right now, it's only specific to juvenile justice cases, because 535 is still in motion. So if that is to pass fully through, then at that point, that's something that typically would be developed in a standard operating procedure policy for the division of how they manage that contact with the attorney. But we have not aligned in a sense where we can say we're confident we know 100% that bill is going to pass, and so we're going to incorporate pieces of that bill tied back into this bill.
So I don't know how you look at it, but I look at it that this bill has to stand alone. I'm not going to make any assumption that some parallel bill somewhere is going to pass. I want this bill to be right, regardless of what the Senate thinks they're doing. So if there's some aspect that you think is going to be taken by 535 that maybe we ought to be putting in here as well, then I'm open to that, because I don't want to assume 535 passes.
I think currently at the review hearings and would be required for new review hearings, workers produce reports with information about all the contacts. One of the reasons we want that more thorough form is so that those monthly visits are more detailed, but that report goes out to every party in the case. So it would go to the CASA, it does now go to the CASA, goes to the parents' attorneys. If a child has an attorney under 535, it would go to those folks too. Like Cassandra said, the kind of in-between communication that's more informal via email or phone is sort of under standard operating procedure. And the workers have their own DCYF attorneys as well. So like they have an attorney internal to DCYF that they could also raise it to, hey, I went to this facility, really concerned. So there is also a process that the division could file something as well.
And just to clarify a little bit more, so with CPS, with 169C cases, there's an appointed GAL, typically a CASA worker at first instance. If there's a conflict or they aren't able to serve that child, then a private GAL is appointed. That private GAL and the CASA GAL is meeting in person with the child every 30 days as well. As of now, there are what's called 90-day court review hearings with CPS. They're typically called the 3-month court review hearing, the 6-month, the 9-month, leading to the 12-month permanency hearing. At each of those review hearings, a court report is presented to the court. DCYF does their own court report, and that's where they're attaching updates from the residential placement that was referred to earlier in terms of the written correspondence. That is attached to that court report. GALs are independently doing their own review hearing court report as well, giving updates as well to the child, their wants, their needs, where they're at in the treatment process. With JPPO, it's a little different. They have what's typically 90-day, it's called 90-day court review, court review hearings, where again, the JPPO is presenting to the court updates as to what has been going on at the facility, how is the child doing, where are they not. And there's also court oversight pursuant to 169C19 that the legislature passed in 2021, placement in qualified residential treatment programs to align with federal law. So this law, as was spoken today, is a little bit different from that, in which in that law, the assessment is reviewed within 60 days of placement. For any child placed in a qualified residential treatment program as defined the Federal Family First Prevention Service Act of 2017, the court shall order an assessment to be completed within 30 days of placement. So now it's going to happen before placement, right? That first part of the statute says prior to placement. This is existing law passed by the legislature on July 9th, went into effect July 9th, 2029. That's 169C19F, placement in a qualified residential treatment program. And then the court reviews that assessment and issues an order approving the placement or changing the placement within 60 days of placement. And that is Court Form 3207, motion for judicial determination in 169B, C, D cases regarding current residential treatment program. So there is already court oversight as to residential placement in line with the Family First Act.
Again, because I'm a simple guy, was that a way of saying that the fiscal note saying we need 9 new judicial positions to support this workload, that we may not need it because we already are supposed to have it?
This is happening typically by motion practice, and then the court reviews the placement, the CAT, what's called the comprehensive.
So I'm looking for kind of a yes
Yes
or
or
no.
no.
So if it's already an existing law and those obligations are already imposed, what this fiscal note is meant to do for this new amendment is to take a look at the incremental costs, the new costs associated with going above and beyond the existing law.
Yeah.
That's what this fiscal note is intended to do.
I can clarify that piece for you. No, because the law that Susan just read for us is specific to qualified residential treatment programs, and that is tied to the Title IV money. So that's the federal money. That's why it's tied to the language that's in the Family First Prevention Services Act. It is intended only for facilities that are going to be provided or requesting the Title IV funds. Not all children in residential placements placed by the state of New Hampshire are in qualified residential treatment programs. So what we're looking to do is capture all of the children placed under 169 B, C, and D. That's only a small portion of that.
The estimate that we did was based on the understanding that because there's an option for any party to raise a 30-day hearing without there being a specific standard, that we would be moving from a de facto 90 to a de facto 30, tripling our hearings, going from about 1,200 to about 3,600. What I understand is that it may be possible to achieve the policy objective while reducing that number of hearings. And if that's the case, it would absolutely lower the estimate that we have.
And if I may add, so we were looking for language, we scoured many states to look for language that already existed in law. This is language that was pulled from, I believe this specifically was from the state of New Jersey. So that is just pulling it as it is written there. Talking about the impact that will have specifically on New Hampshire and the courts, we see the ability to make those changes that Lissa mentioned. We had not had many opportunities to speak with Erin prior to this, so apologies for that, Erin. But I do think we would have had no problem making those changes had we been aware of the impact on the courts and
And
had
same-
some of these conversations.
And same with our request for additional attorneys, because we were going with what's not in practice, which is the every 60-day review hearing and the possibility of every 30-day. So either way, it would be by minimum an additional 1,722 hearings with 1573, and at the maximum, about 3,444 additional hearings. And that's where we came up with our need for additional attorneys.
There's no attorney request in this bill.
I didn't understand that last comment.
As far as my review of this bill, there's no request for attorneys in this bill.
another? No.
There is
And
none.
it's in
It's,
the fiscal worksheet.
okay, so again, because I'm simple, it sounded to me, Ms. Cregan, that in just having this conversation, you're comfortable with a different interpretation of what's been written such that it reduces the workload you thought may be incumbent upon the department. Again, I don't want to put words in your mouth, but did I hear that right?
I don't think I can say yes or no, but I just want to make sure I understand your statement. I think that it would need to be changed in the way that it is written in order to reduce the number of hearings. But
That was my next question. And to get your interpretation so that there's no confusion, do we need to change the language, and can you participate in helping do, good? That's great.
absolutely.
Yeah, if you can work with the Child Advocate's Office to
Certainly.
get that. Okay, that'd be great. Thank you. Oh, okay, let's have a technical question.
Okay, so, because I come back to this idea that a lot of decisions need to be made in a resource-constrained environment. And so when I'm reading on page 4, lines 10 and 11, it basically says that the decision for the child's residential treatment program is meant to be providing the most effective and appropriate level of care. And so the question of availability jumps in. And so I wonder if maybe we could add a couple of words to make sure that the decision is most effective and appropriate given available alternatives.
That is the language that is from federal Family First Prevention Services Act. And
So
we
the
would
feds
be-
got one right?
They did. They did, and so we would
Should
not want to
we
change
have
that
that
language.
reflected in our language then, since we're trying to emulate the feds?
No, so we have. So that what is written here now, the most effective and appropriate level of care for the child in the least restrictive environment, that language is from the federal language.
Okay,
And so
and-
we are making sure that that is consistent. And if we
And-
added something outside of that, such as an exception due to resources, we would not be aligning with the federal requirements for placement.
And then they would not give us money.
Well, if they caught us.
Little liability issue there. Pretty much.
Kevin, could you talk to us for a minute about when we go forward with this, there are additional, at least in the fiscal note, they talk about additional staff and appropriations that would need to be, it seems like authorized in the bill.
Right.
Which were not previously.
That's correct. And the bill is introduced, there were no appropriations and no authorizations for new positions. There are now in the bill as amended by the House for the HHS piece, but not for the judicial branch. And I think those positions and cost estimates in the bill as passed by the House are different than what HHS is now predicting and will be different from what they predict in response to this amendment that's being worked on now. So, so we'll get some new numbers from that and we'll include them in the fiscal analysis and likewise with the judicial branch. As far as what should be in the amendment that's being developed now for an appropriation, I don't know how quickly we'll have that number. I don't know for the time being, perhaps you should consider including a placeholder that could be with a number that could be added later. That's really up to how quickly the department can get me some information.
I don't know that everybody heard Representative Edwards letting me know that we need to have an official amendment drafted by OLS by Monday.
Yeah.
So that the division as a whole can act upon this bill and be ready to go on for a Friday. We're going to vote on Friday.
Yes,
Our-
no later than.
So I'm going to need, I will go over to OLS and have it drafted, but I am going to need all these pieces from all of you. Okay? Right.
I
Thank you.
do have an additional question.
Oh, Representative Priest has a question.
Yes. On the development of a file management system for $500,000, that seems awfully high, and I would just like to get some clarification on that. For the work that's being done.
In the, apologize, Nathan White, Chief Financial Officer, Department of Health and Human Services. Representative Priest, you're looking at the original fiscal note. The IT team has actually gone back and further investigated that, and right now they are estimating that that's going to be a higher cost. Correct, because either it would be an in-house customization or it would potentially be an off-the-shelf product. But I can have Dave Wieters come out to the next working session. He's our IT director to speak to the specifics of why those costs would be so high, if you'd like.
Do you have an estimate, Mr. White, of what those costs would be?
The most recent estimate I've received from Dave is approximately $1 million. The other alternative is to continue to use more of a Windows folder-based system. The costs represented there would be to develop a true certification system. Because I think what's important to remember here is we're basically taking on almost like a joint commission type function where you're going into an organization to certify them. We don't have any existing IT system that we could use to, run numbers and case file and follow up and all these other things. It would have to be completely manual, and it'd probably be a Word, Excel, Access-based system otherwise.
So can I just say that I think what the general policy is that where possible, we would rather rely on a vendor that has expertise in a developed system than to have an employee basically do a roll your own with Microsoft tools, not only because that person's not a subject matter expert and has a steep learning curve, but because then we become obligated for every Microsoft update. And if that smart person goes and gets another job, then we don't know what's in the system and we can't maintain it. So I think the cost I'd be most interested in is, and this is for you too, Representative Priest, I'd be most interested in what the estimate would be to procure an off-the-shelf product with the vendor support than to roll our own.
And that's the updated $1 million that we've submitted in the fiscal note worksheet for the amended version.
I blocked Kevin because Kevin had something he wanted to say.
So just as a follow-up, what have you been using now on the current system? Because you're supposed to be doing this already. And how are you sharing this information and inputting it?
Is this a question for DHS?
Yes.
Yeah. We're going to have a question for you.
Oh no, I'm about to shortly be towed. Are you sure I can't take that question by writing? No? Okay, I'll say.
I'll try to be quick. So we do everything manually now. They're all in our shared Windows File Explorer separate folders. One of the reasons why it is highly burdensome for us to get records to the OCA and others who are interested is it's a manual process. We are swimming in different Excel spreadsheets that the data doesn't match. So it's really hard for us to put that together to get aggregate data. We have providers sending in monthly workbook files in Excel that are not analyzed and aggregated either. So we have a whole bunch of manual places that really don't talk to each other and can't give us that big picture system and give us the ability to share it easily. And that's what we'd need if we're increasing the number of visits, the number of reports. Right now we get things by fax, we scan them, we put them in files, and it's very slow and tedious.
So I would imagine that creates at least three problems. You know, you got an access control issue. Who's going to get access to this system? You have audit trail issues because it gets to be confusing who accessed what information at what point. And then you get a sharing issue where if the OCA wants access to the database or the judiciary does, then it's much more difficult to arrange sharing. Those are the three problems I would guess you're having.
Yeah. Additionally, we could use this type of system to allow providers to upload certification information more quickly to speed up their certification process.
Just as a follow-up, is your present system something that other departments can view? And no, so thank you.
Other departments cannot access it. No, it's all within HHS, and certain parts of HHS, like parts of DCYF that need that information, can access those folders, but it's all very manual and individual by folder and by file. I wouldn't call it a system.
Any other? No one else wants to talk? Okay.
Okay.
I felt like I stopped Ms. Cregan from saying something. You got
Oh, what I was saying is that I'm shortly about to be towed.
Oh, she needs to go get out there before.
But I will stay here and pay that ticket if you have any more questions for the judicial branch. Okay.
I think you should go and get your car. Go. I want to thank everyone for coming
Thank you.
and helping us get through this. And I guess we'll see each other again. I hope before Monday that I will hear from you. Okay? Thanks.
Great. Thank